Good morning all. We are here for a hearing in the matter of CFI 012-2019 before His Excellency Justice Ali Al-Mohammed Madhani. The claimants are represented by Carlo Fedrioli. The lead counsel is Tim Prudo. Defendants are not named. Thank you.
Good morning, Mr. Prudo.
Yes, good morning, and may it please the court. You have the representation, and I appear today on behalf of the applicant. As I'm sure you are already aware, also present in the room is the Assistant Registrar, who observes me as part of the Part 2 process.
Sure.
Mr. Fedrigoli sits behind me. Could I just please start by ensuring that you have the necessary materials? Perhaps most importantly, from my perspective at least, a skeleton argument.
I do have it.
I'm obliged. I'll deal with why that seems to be of a certain length in just a second, but could I also then ensure you have a hearing bundle consisting of 2 sizable volumes in white?
I do have it, yes.
And then there will be, in addition to that, an authorities and materials bundle with a spiny binder.
Right.
I appreciate that you will be very familiar with a good portion of the authorities bundles, but some of it, for reasons that I'll come to, relates to the legal position in the BVI, British Virgin Islands.
I noticed that, yes.
And that will go to the point that the British Virgin Islands has the sort of framework of cooperation that they're seeking to invoke here in this jurisdiction.
Well, I see. Also, for your comfort, I would like to confirm to you, I have read the suggested reading material.
I'm very, very much obliged. I wasn't certain whether the court would have time to do that.
But I did, yes.
I, in fact, have the benefit of having been the advocate on the application of the British Virgin Islands. So if it's any consolation, materials in the British Virgin Islands were even more voluminous to get the original order, and it's right to say that we've only included this amount of material here out of an excess of caution, as it were, so that if the court today were to want to know more about the factual situation, I would be in a position not only to deal with it myself, but also to take you to the relevant materials. So the idea of me pointing out the pre-reading is really to give the court the opportunity to avoid ploughing all the way through the material, which supports the core that I listed in the pre-reading. I hope that makes sense.
It does, yes.
The key document is the draft order, which is, if you like, our finish line today. And that document is at the very end of the 2nd volume of the bundle. This, as the court will appreciate, is a Part 8 application, and that reflects the fact that the facts, although sad and of significant local effect here, are not in dispute for the purposes of this application. And one of the standout characteristics of this application is, although I appear on behalf of a British Virgin Islands liquidator, in all practical respects, this is a fraud with local effect and distress. Unfortunately, and as you will have pre-read, there are as many as 7,000 victims local to this court.
I noticed, yes.
And of the other entities, 4 known other entities at the moment, 3 of them are locally incorporated. So it just so happens that this is the first request for assistance, but one could easily see in the fullness of time, if matters progress with winding up proceedings in this country, that the shoe might well be on the other foot, in the sense that there may be requests for assistance in the opposite direction, as it were. One of the difficulties, not unique to this fraud, but one of the difficulties for my instructing client, the liquidator of the BVI company, is that there are multiple arguments as to whose money that we are currently finding, whose money it is, which entity has the best title to that money. It seems highly likely that there will be other insolvencies because they are so overlapping, and it's just that the BVI one has started first. So if I could now turn then to the application itself, excuse me. And that if I could try and encapsulate what the application is and the limits of the application.
Yes, please go on.
This court has had a number of pieces of litigation passed through it for the purposes of order and judgment enforcement, and cases with which I realise this particularly constituted court is very familiar with. On appeal, the DMB case, which I understand of course you are familiar with, discusses at some length how it is that the court, in recognising in that instance a judgment, doesn't need to try and second guess what will happen as a result of that, doesn't need to assess even whether there are assets in this country to enforce against. The start and finish of the consideration is there the enforcement of a judgment or order, and here today the recognition of the appointment in the British Virgin Islands of the liquidator. Without intending to make a pun, it seems to me that we are in virgin territory so far as recognising the order of appointment. We have been unable to find, and the court may have better knowledge, we have been unable to find an example of the type of comity and international cooperation that has been discussed in other cases being applied to an overseas liquidator. So, to that extent, although the principles are very much overlapping, and they are the same principles that we will be invoking today, we don't believe that there is an existing precedent for what we're trying to do. So, to the extent that it feels we are all in unknown waters,
Well, it's nothing I can recall too, is it?
I'm obliged. But there are, of course, good examples of this court recognising that it would be entirely defeating of proper legal rights to allow the structuring of people's affairs to put assets out of reach of legitimate creditors. So, in a sense, what we are talking about here is the mirror image of the facts in cases like, I hope I'm pronouncing this correctly, Akhmetova and the Strait establishment. That happened to be a Liechtenstein Anstalt, but in that case, in paragraph 44, I have read your own remarks dealing with examples such as the Ablyazov case, the Pugachev case, how structuring should not be a way of defeating legitimate claims. Ablyazov, for what it's worth, keeps a good chunk of the commercial bar in the British Virgin Islands busy. So this is another oddity about this application. BVI, the British Virgin Islands, coming to another country when very often it tends to have been other countries coming to the British Virgin Islands, which simply reflects the sheer volume of the incorporations business in the British Virgin Islands. If one has to hand, please, or if the court has to hand the skeleton argument, could I ask you to turn then to page 2, numbered page 2?
Yes.
You've already indicated the court's pre-reading in relation to the fact of the 7,000 local victims. It's right to say that although the liquidation has been ongoing since January, for obvious reasons, the piecing together of the factual information continues, particularly in the area of who invested in what. And in fact, as a precursor to this application, I appeared in the British Virgin Islands Commercial Court making clear that issue, because Mr. Federigoli behind me had great success in an initial recovery. You'll have read from the securities company, and that demonstrated the different attitude between financial institutions as to the existing British Virgin Islands order, that because of the way that the applications process worked for the fraud, there were certainly at least arguments as to who invested in what and how that money had come into the hands of FCI. The British Virgin Islands Court, with me appearing before them, came to the conclusion that it was better to get on with the necessary work to get to the bottom of that than stop and try and work out at that early stage who had best claim to some millions, but nowhere near the right number of millions that this recovery could entail. So we have then, at paragraph 7 of that skeleton argument, a summary of the evidence that we have two financial institutions here currently feeling unable to assist until this order is recognised. Now, we haven't expended resources arguing with those financial institutions, but we rely, we pray in aid, as the saying goes. That problem, that practical problem with those two banks, as a basis for the need to make this application. As to the jurisdiction of this court to consider the application, we set that out from paragraphs 9 onwards, and I'm in the court's hands as to how much further detail you would like from me.
Well, Mr. Rudd, if you bear with me for a second. I mean, the two institutions, financial institutions you're mentioning here, right? Mashreq Bank and Baroda Bank.
Yes.
Were they like local banks, are they onshore or offshore banks? And what's the relation, between these two institutions and the DIFC?
Yes.
I understand you know the difference by now.
I do, yes.
When it's come to the jurisdiction between the local courts and the DIFC courts.
Yes, these two banks.
Because these banks usually are under authority or jurisdiction of sometimes another court. You know what I mean?
Yes. So the distinction that you're drawing is in fact a distinction that one can see in the enforcement guide, where the Bahraini decision dealt with banks subject to this court's jurisdiction, and where there was a treaty. We have the benefit of neither of those, unfortunately.
Yes.
Both of the two banks, and it's obviously impossible to say how much, if any, money they continue to sit on, but we certainly believe one of them has close to $2 million US. Both of those two banks are onshore in the sense that I understand that term is used here. And it's a phrase that I also understand to be used here, conduit jurisdiction. The thinking is, and again I stress that this court doesn't need to determine today whether or not there are proper prospects for this happening afterwards, but the thinking is to localise the order, if we get recognition here, in the courts of this country outside the DIFC. It may be that with an order out of this court, if that's what happens today, that one or both of the two financial institutions will see the writing on the wall, as it were, and cooperate, but at the moment we don't know. So we are certainly intending to try, if we get an order today, because of course we have the creditor pool and the asset preservation issue to consider, to see whether either or both of those two banks will simply capitulate on their position and provide us with the information. If they do not, we will need to localise the orders outside of this court, but in this country. But we don't know yet what they'll do. What they haven't been prepared to say is whether they would take an order from this court as being enough, as it were, but we have to work on the basis that they may not.
So my understanding for now, if it doesn't work like directly, these two institutions would cooperate with you according to the recognition of this course. Otherwise, you try to take the approach of DNB, of this is the recognized judgment of British Islands to be sent to Dubai court, execution rate as it is a DFC court judgment.
Yes, and we would do that, and we would accept now that we would do that, but the court today...
I mean, in case, yeah, I don't know, yes. It's just speculation, I guess.
Yes, doesn't need to say, prove to me that you'll be successful about that.
Obviously.
So yes, we're ready to do that if we need to, but we hope that we won't have to, I suppose is the
well, yeah, what I understand, to what extent I'm bound by the Court of Appeal judgment, which is by late Chief Justice Michael Huang.
And the reason I mentioned at the beginning of the hearing that I would deal with why this skeleton argument is quite long, really, for an application that at its core is a straightforward one, at least in terms of volume, perhaps not straightforward in terms of jurisprudence, is that we have taken the liberty of placing in the skeleton argument what we consider to be the most on-point language, both about international comity as it relates to order and judgment enforcement, but also information in relation to insolvency in particular. So I'm very conscious that you in particular, but this court generally, are well aware of what the DNB Bank decision says. So unless you wish me to take you through that again.
Not at all, not at all.
I'm happy, as it were, to take you past the section on international comity as it relates to judgment enforcement, and then take you to the question of comity in cross-border insolvency. And that's to be found starts at page 7. Once we get to that point, it's clear that really, in terms of the skeleton argument, there is relatively little left. Paragraph 16 of the skeleton argument makes what I would submit are uncontentious points about the value of a workable international insolvency regime. I would add to that where one has 7,000 known victims of fraud and at least 2 jurisdictions which, in your own judgment, you would likely characterise as secrecy jurisdictions, the need for international cooperation is only emphasised and underlined.
With the possible 7,000 victims, they are not a possible 7,000 creditors to the FCI, isn't it?
Well, the way that the application process worked is that the form one applied through the essential entities, but the money ended up in a brokerage account in the name of FCI. This is, the court with respect has hit upon precisely the major headache in this liquidation. If one applies through Essential and Tadawal, but the money ends up in FCI, strictly speaking, you are more properly identified as a creditor of the people that you handed the money over to. So until the other entities themselves, so Tadawal, Essential, the full names of which are in the materials at paragraph 11 of Mr. Fedrigoli's statement, until they are themselves in insolvency, they don't have a basis to make their own claim in the FCI insolvency. Fortunately, from a practical perspective, the brokerage house here that handed the money back to FCI didn't concern itself with the people requesting that money to demonstrate to them that FCI had the better claim. They were properly, I would submit, satisfied with the fact that a court-supervised collective insolvency proceeding was going to be put in charge of that money. What we expect to happen is that of those 7,000 people, when they get, if you like, bad news, although they've obviously had plenty of bad news already with the facts, but when they find from FCI that their claim is necessarily rejected, I don't say that without sympathy, but from a legal perspective, rejected, they have the opportunity to renew that application in the BVI courts, as one would expect. Or they can more properly make an application to one or other of the essential entities. Sooner or later, one of the creditors amongst the 7,000 that applies to FCI, because FCI has had some press about the fact it's in liquidation, sooner or later one of those people, as a reaction to being rejected inevitably by the FCI liquidators people, will apply, we expect, to wind up one of the essential entities. Once that happens, and one of the issues that I am in this jurisdiction to discuss with candidate liquidators for essential, once that happens, the proper course would be the liquidator of that entity, the essential entity, would inevitably make a claim in the liquidation of FCI. The hope very much is that of the 500 million US dollars thought to have been the subject matter of this fraud, obviously it's overly optimistic to expect a full recovery of that amount, but if there is a larger recovery than we currently have enjoyed, there will at least be funds, not for everybody, but there will be a lot more in the pot for an essential claim, proof of claim as they're called in the BVI proceedings, to be worth something. And the judge in November in the British Virgin Islands expressly acknowledged the fact that in some senses there are inevitably going to be competing claims on the money that FCI recovers, but better that it be recovered, and recovered soon, so that there's a single identified place from which people can, or to which rather, people can make requests. If sooner rather than later one of the essential entities is placed into liquidation, and one would expect, although it's not a matter of requirement, one would expect that to be in the jurisdiction of its incorporation, it may be that people who are properly creditors of FCI look to FCI to bring a claim in the liquidation of essential, but that seems less likely because FCI, on the facts, seems to have been the end rather than the beginning. It never received funds itself. And the difficulty in the language of the application forms...
Excuse me.
Yes.
But I thought FCI used to be an investment pool where Essential and other Dubai entity were injecting money into.
Yes. Yes.
That's how that is my understanding.
That's right. But when your account opening documents talk about FCI, but use language, well, the first practical problem is, perhaps intentionally, with the benefit of hindsight, the missing party to the agreement is, of course, FCI. So these fraudsters had the sense to make sure that when you open an account, you didn't open it with the entity that would end up with the funds. The account opening documents have the counterparties to the agreement as the individual opening the account and the essential entities. And the essential entities are described as having the obligation to look after the funds. The fact that they looked after the funds by investing in FCI doesn't give an account opener direct recourse to FCI, which is why often And entirely understandably, a subset of the 7,000 victims hear about FCI liquidation, they've read press about it being where it is, they make certain assumptions about the use of a jurisdiction like British Virgin Islands, and quite naturally, because it's someone to deal with, they contact the liquidator in the British Virgin Islands and say, I've lost about $100,000, and that seems to have been the ballpark, the average amount. Please provide me with details as to what's going on. In that process, the liquidator of FCI has often had to say, we don't believe you are a creditor of FCI. We believe that an entity called Essential will have a claim in our liquidation, but unfortunately your problem, as it were, is with Essential. Unfortunately at the moment, and because of the level of investment, it's a wise thing if you're a fraudster to pick a large number of medium-sized investors rather than a low number of very large investors. Nobody has yet stepped up to the plate to fund Essential. As soon as Essential gets going, Essential, we expect, on behalf of FCI, will be in touch with FCI. Looking at it the other way around, one of the frustrations that FCI currently have is they know full well that the main creditor is effectively a hub for a large number of other sub-creditors, if you like, creditors to that creditor, but FCI are not in a position to even make an interim payment out if they think they're sitting on monies for Essential and no one is currently in control of Essential. The problem has been on the facts, getting full information from the people who are in charge of FCI. They don't provide. The information is a requirement. A statement of affairs is a very standard thing in insolvency, and that was requested very early on. That information has only crystallised the view that the funds that FCI are currently sitting on are, in all probability, not FCI's, but in fact Essentials. What FCI are clear about, or the liquidators are clear about, is it's certainly not FCI's to keep. But they are currently having to spend money, as little as they can get away with, to get to a point where they can, for the time being, custody what there is, which is Mashrek and Baroda. We need to get more information out of them. And then hopefully energise one or other of the Essential entities, which would be here, to be put into liquidation or a petitioning creditor to do that, so that someone exists for the liquidator of FCI to deal with. That's the real benefit of somebody else starting the insolvency process. And until that happens, there's only a very limited amount that can be done. What FCI can do is take the steps that it's taking in relation to Mashrek and Baroda here. And there are other jurisdictions, and obviously I need to be careful because this is a collective insolvency proceeding and this is a public event. There are other efforts being made to track down other monies that FCI may also sit on for the Essential entities, but they at least have the power to chase the monies if in those other jurisdictions the accounts were in FCI's name as well. So in many respects, and not unusually, they're trying to seek preservation of the funds and worry about the best title to those funds later. It has been a very slow process, precisely because there are so many people involved and the accounting information is so poor. Because there are so many expatriates as investors in the scheme, there's a vast amount of electronic data to trawl through, and when people submit a claim to FCI, through no fault of their own, they're not lawyers, they're much less forensic accountants, they provide incomplete material. Very often they have very little material for their investment, and that sifting process explains the delay on an objective basis between January of last year and now. So the process is going as quickly as we possibly can, and because FCI were conscious of the argument that another entity's money was potentially being spent. We are not here today simply on the basis of the original order, which gave us certain powers to move forward. We actually made a specific application about taking the step of seeking recognition here, for which I had to explain the two-stage process, if you will, of the DIFC court and then the courts onshore in this country to the BVI court. They realised the various hoops that we have to jump through and are prepared to let us try.
May I ask you, what was the main reason causing the bankruptcy of the FCI? Is that the misuse of the funds by the directors? My understanding again is that the directors of FCI are the people in charge here, and the
Yes.
same people of the Dubai entities, isn't it?
Yes, two of the main players are serving extremely long sentences of imprisonment in this country.
Yeah.
The third main player, someone called Jeffrey Lee, is an Australian, and he is at liberty. I understand him to be unable to come to this country for obvious reasons. All three of those individuals were in control of all of these entities. And in fact, there are more entities with extremely similar sounding names. And it's difficult not to come to the conclusion that the similarity of the names relates to the underlying intention of the scheme. The scheme ran, like all Ponzi schemes, ran successfully in the initial period, not because of any success in foreign currency trading, but because there were inbound investment funds at a sufficient pace, usually because, and traditionally because of the level of interest promised, to pay out. So there were fictitious payments out. There will be the usual headaches for those, in the Stanford fraud terms they're called net winners, Madoff terms they're called net winners. The lucky ones who left the scheme early may feel at the moment that they're very fortunate. Well, one only need to look at what happens in these sorts of situations to know that in the fullness of time, their windfall profits will be recovered. But as soon as people started to understand that the scheme was not all that it was supposed to be, inbound investments stopped. There was, so far as the public were concerned, the investing public were concerned, pauses for restructuring. There were delays on payments out, because you always have the opportunity to redeem. Those delays got longer and longer. There were various public pronouncements as to why there were delays, and then eventually the individuals who ran the scheme went to ground. The game was up. And Lemos is now, I think, serving a 500-year sentence in this jurisdiction. So, to answer your original question, all of the same individuals controlled the various companies. One can plausibly infer from the pattern of companies that the reason that there were several Dubai incorporated entities involved is because of where the customer base, the targeted customer base, were. They certainly weren't the British Virgin Islands. They were all here. As it happens, they seem to have been largely cabin crew. The airlines were targeted in particular. But dealing with a local company for the purposes of selling the idea was obviously the preferred modus operandi for the various players who controlled the entities. It made the applications process that much more plausible, and the way that FCI was sold to the applicants was that there was a freedom of regulatory oversight in the British Virgin Islands that let them maximise the profitability potential of the overall Forex scheme. So one of the great ironies of the scheme is that it relied upon the credibility and sophistication of the regulatory regime in the British Virgin Islands as providing more flexibility, when in fact the British Virgin Islands was being exploited as a way of making FCI more remote and more difficult to wind up. It's no coincidence, we say, that when assets were identified, they weren't in a Emirati incorporated company, but they were more difficult to get at because they were in the name of FCI. So the perpetrators of the fraud knew that whatever efforts were made to recover that money would necessarily involve somebody having to go to wind up a BVI company, which was that much more difficult for someone who'd invested perhaps 100, perhaps 150,000 US at this end. In effect, prohibitively expensive. So what happened in the efforts in relation to FCI is a number of creditors were identified, so that if Mr. Leahy, the remaining principal player at Liberty, made good on his various promises and paid one of them off to pull the rug, as it were, from under that creditor, there would be an immediate supporting creditor. And unfortunately, experience tells us to have several lined up, because the cynic involved in the scheme may make a payment, a midnight hour payment, to the petitioning creditor to have the whole thing collapse. What in fact happened at the hearing of the petition, bear in mind that there was a provisional order made, provisional on the basis of the funds that Mr. Fedrigoli had identified at the brokerage, but when the full order was made in January of 2018, 15 minutes before the hearing was called on, Mr. Leahy was in touch about being able to make things good and wanting an adjournment. So it really was textbook stuff from the fraudster. Of course, he was unavailable for at least 2 weeks. There was a suggestion that he would appear through local lawyers. They never materialised, but he was still asking for adjournments really there and then. Since that time, he's been remarkably unforthcoming about the information in relation to the company, and really that's no great surprise. It is hoped that as and when one or more of the essential companies enters a collective insolvency process, there will be collectively more information to chase down assets.
I see.
One of the aspects that the court needs to consider in considering our request, our invocation of comity, is the behaviour and attitude to that issue of the requesting country. And I deal with that at my skeleton argument, paragraph 19 on page 8. So we're now down to the last 2 pages of the skeleton argument. And we have, for the court's assistance, a short expert's report of Mr. Peter Tyler-Smith, a member of the BVI bar, whose purpose is simply to set out the fact that the concept of comity is a well-known principle. It's hardly surprising that it is, because the major financial engine, if you like, of the British Virgin Islands is company corporations and company services. So although we don't have the full artillery of the UNCITRAL law, inbound requests for, in effect, exercise of comity interests is a very familiar aspect of commercial practice in the British Virgin Islands, both as it relates to receivers, Ablyazov being the most publicised recent examples, as well as in relation to insolvency proper, as it were. And in the materials, there are the May 2017 cross-border cooperation arrangements, which extend even, and this, we're not claiming that this is unique, but it goes to the issue of whether a credible request is being made today. Those cross-border cooperation guidelines even go as far in the annex of those guidelines to joint hearings, which have been going for some time onshore, but certainly in an offshore context, are a relatively new thing. And the British Virgin Islands adopts those. So, in all proper senses, and although it's sad to say there's every chance that this set of facts will require assistance the other way around, in all proper senses, the British Virgin Islands is a court that can be thought of credibly as someone that it practices what it preaches, if I may put it that way. So foreign representatives are assisted, and there are the practice directions under the insolvency rules, the Judicial Insolvency Network guidelines, which are a standard form. The Cayman Islands and Bermuda have a similar approach. Again, neither of which are surprising, given their position in the offshore corporate world as well. If I could take the court, unless the court would like to hear from me on any other aspect of the issues raised in the skeleton, I would like to take the court to the draft order.
Yes, please.
I'm afraid it's going to take some strength. It's at the very end of the second bundle. There's just one unusual aspect that's easily explained, but I'd like to take the court to.
Well, I just want to, before we get to this, I would like to know more about this, like the Supreme Court of, I don't know, just give me a second, I tell you how you describe it. It's
Yes.
the Supreme Court of the Caribbean,
So
and the BVI Court, and
yes, it's a very fair question, and it's easy living and working in that region to assume that people know a lot more about it. Let me fill some gaps in. The Eastern Caribbean Supreme Court is approximately 50 years old and encompasses, as the name Eastern might suggest, courts from as far east in that region as Grenada and as far west as Barbados, and is what people would consider to be the Caribbean properly so called. Anything above Hispaniola, which is the Dominican Republic and Haiti, people would dispute as properly being the Caribbean. So Bermuda, for example, the Bahamas, the Turks and Caicos, although the water looks the same colour, are not officially in the Caribbean. In the Eastern Caribbean, there is a unified court system so that the procedural rules are identical. Certain statutes differ across the jurisdictions. So, the admissions rules for Grenada, for example, would be different to St Kitts and Nevis. St Kitts and Nevis are a confederation, so they are viewed as a question of law as being the same country. The Eastern Caribbean Supreme Court has a Court of Appeal which travels, but hears appeals from all of the various constituent members, and one has the right of audience in the Court of Appeal on a case if you are admitted in the court below. So there are certain parts of the Eastern Caribbean Supreme Court where I am already admitted, and I would have the right to appeal on an appeal there, but I wouldn't have an absolute right in the Court of Appeal on any case.
so it's an appeal to the BVI, isn't it?
Now, what's confusing is, although in reality, on the Eastern Caribbean Supreme Court circuit, all serious commercial work is done in the British Virgin Islands. The commercial court is the commercial court of the Eastern Caribbean Supreme Court. So, it's fair to say that it is just as much Anguilla's Commercial Court, or St Kitts and Nevis' Commercial Court, that is BVI's, but it's housed in the BVI. Now that doesn't necessarily mean anything, because the hub, the centre of operations for the Eastern Caribbean court system as a whole, is in a place called St Lucia, which, although a large island, has none of the commercial dispute work that the British Virgin Islands does. The clear reason why the British Virgin Islands has court lists that read like something out of a Russian novel often is because of its volume of incorporations business and the longevity of its incorporations business. So people in practice far earlier than me did a very good job of selling BVI companies in the former Soviet Union, the Eastern Bloc generally, and in particular in Hong Kong. So any joint venture dispute in China, there is an extremely good chance that the actual litigation, odd as it may sound, will be fought out in the British Virgin Islands. So very often the advertising of a liquidation of a BVI company, and of course one of the obligations in advertising a liquidation is to advertise where creditors are most likely to be. Very, very often it is advertised in Hong Kong and mainland China. The proportion of commercial court work that's done in BVI, British Virgin Islands, as opposed to any of the rest of the region, I would put it at least 80%. But if two parties in, let's say, St Kitts have a dispute, and there's one going on at the moment that is, on any view, pretty large, they can choose to have that transferred to the commercial court in the British Virgin Islands, even though it would stay a Nevis or St Kitts dispute. So then we have a situation that the court is sitting in the British Virgin Islands, but is actually hearing a Nevis case, and if you're not admitted in Nevis, but are admitted in the British Virgin Islands, even though the court is in the British Virgin Islands, you'd have no right to appeal. It's extremely confusing. The Court of Appeal for the Eastern Caribbean Supreme Court hears both commercial court disputes as well as, if I can say, ordinary court disputes, and then one tier above that, subject to the grant of permission, you have a right to go to the Privy Council of England at the moment. A complicating factor to some extent, or perhaps some would say a simplifying factor, is that there is a growing impetus behind the Caribbean Court of Justice. And the Caribbean Court of Justice is based in Trinidad and is jointly funded by all CARIBCOM members. And CARIBCOM members are a little bit like the EU, although the EU is a touchy subject for a British person.
It's a smaller area.
Yeah. And the CARIBCOM funding members have the stated intention of eventually, over time, replacing the Judicial Committee of the Privy Council. So the idea is to bring the final appellate court process in the Caribbean home, if you will. One of the oddities, or two of the oddities about the Caribbean Court of Justice is not everybody is signed up to it. So Trinidad, bizarrely, houses it, has played a part in funding it, but doesn't adhere to it, so doesn't sign up to it and hasn't actually got cases running through it.
Quite weird, yeah.
Jamaica, in terms of population size, Jamaica after Trinidad is the next largest, also hasn't signed up, so Jamaica's appeals finally would go to the Privy Council. And then certain jurisdictions which are British overseas territories, so British Virgin Islands being one, Anguilla, Bermuda, Cayman Islands, they're not eligible even to have their appeals go to the Caribbean Court of Justice because they're only associate members of the CARIBCOM nations, because if you are a dependent territory, which is mainly the British ones, but there are French ones in the Caribbean as well,
you're not eligible to join the CCJ. Within the Eastern Caribbean Supreme Court circuit, there is Grenada, I mentioned before. They recently rejected at a referendum the opportunity to join the CCJ. So they also fund it, but their population just rejected using it. In Central America, to make it that much more complicated, it's fascinating to me, I'm afraid I could bore the court for a very long time. Guyana and Belize, because they have an English common law background, they are both signed up members of the CCJ, so they have appeals running through the Trinidad court system as it consists of the CCJ. And because I'm admitted in Belize and Grenada, I can appear in the CCJ, but I could not appear on an appeal from the British Virgin Islands because they're not eligible to have them heard there.
I see. It would follow the procedures where the procedure originated, isn't it? That's how it works.
Yes.
Yes.
Yes, and over time it seems inevitable that support for the Caribbean Court of Justice will continue to grow. At the moment, it has fantastic facilities, a lot of money, frankly, and not enough cases. The marketing, if I could put it as bluntly as that, the marketing for jurisdictions like the British Virgin Islands, whether express or implied, still includes an element of, if this all goes wrong, one can be sure that you can go to the British Supreme Court, same people, different name. And there's a degree of advantage to being able to say that. I think that over time, that advantage is being reduced because people are more and more aware of the calibre of the judges in the Caribbean Court of Justice, one of whom was a Brit anyway.
Yes.
We
do have some of our judges, like colleagues of this court, do serve in that part of the
world. Several of whom I'm very familiar with.
You must have appeared before them.
Yes, and without sounding discourteous, the usual suspects, if you will, appear in a variety of places, including the courts of appeal around the Caribbean, outside of the Eastern Caribbean. So, not all of the Caribbean sits within the Eastern Caribbean Supreme Court, and places like the Turks and Caicos Islands and the Bahamas and the Cayman Islands sit outside of the Eastern Caribbean Court. They have their own court of appeal, and on those courts of appeal, people who sit here, judges who sit here, also sometimes sit. In the Turks and Caicos, for example, Sir Robin Auld sat as the commissioner at a commission of inquiry. He sits in the Bermuda Court of Appeal. Evans J sits in the Bermuda Court of Appeal. And to complicate matters further, you have first instance judges in one island who may sit in the Court of Appeal in another island. So the recently retired Bermuda Chief Justice, Kawley, now is the Court of Appeal judge in the Cayman Islands, and the now deceased predecessor to him would be the Bermuda Chief Justice, but also a Court of Appeal judge. So I could on one week appear in front of the same judge in Bermuda as the first instance judge, and then he'd be the Court of Appeal judge I was dealing with the following week.
Interesting. Well, I think they will make benefit of a different retirement age, maybe, between these islands.
That's certainly true, and it's quite clear that the jurisdictions benefit from the years of experience that those types of Sir John Chadwick has. There's not much he won't have seen. And if you have an application to make in front of him, you better be ready.
Yes.
Which is all to the good. And in fact, that plays into the marketing issue. People love to know that experienced judges from whichever country are ready to hear the appeal. And very often, because there's a degree of travel involved for those judges, the idea of having an emergency hearing out of hours or by telephone is something that doesn't faze them at all. Keep in mind that although the British Virgin Islands are on the road to recovery now, during the time that we were very close to issuing the winding up petition in these proceedings, the British Virgin Islands was pretty much destroyed in a hurricane. So I was just explaining to my colleague, Mr. Fredrigoli, we were preparing and trying to make the winding up application when the judge, the court, and all counsel were separately in different places. And we had at least twice as much material as this, relying, as we had to at the time, on things as basic as Skype. So there was a degree of resourcefulness that we were having to display. So to appear in surroundings as luxurious as these is a reminder of how difficult things were at the time. But I'm conscious that I digress a little. If I could just...
Well, I thank you for that clarification.
If I could just refer you then to the form of order.
Yeah.
The only thing that I would like to clarify is why it is that we originally had 2 liquidators and that we're now down to only 1. Angela Barkhouse was the original co-appointee, and in what is known in the British Virgin Islands as a block transfer order, she was removed as co-appointee simply because she changed employment and went to another insolvency organisation. So Mr. Pretlove became a sole liquidator. Of course, if there was ever a reason to have a new joint appointee made, and that's very often because assets in another country are identified and there's a need to have someone on the ground, that extra expense will be envisaged. But at the time we made this application, we saw simply no reason in incurring the additional cost and having somebody else involved. So that's the reason why we mention it in the order, because what we don't want to do is to have the order recognised and then try and deal with the 2 banks here on the basis of the recognition, but have what we would say spurious issues raised about, well, the original order has 2 people on it, the recognition is in relation to 1 person. So we wanted it on the face of this order that there used to be 2 and now there are only 1. Obviously, at the time that we supplied the draft order, we weren't clear what date this application would be given, and we didn't at the time have a date of the finalised statement of Mr. Fredrigoli, so we would add that subject to the court being prepared.
Where I might have official reference to the removal of the second liquidator?
Yes, so if you if one looks at the draft order,
Yeah.
in the preamble, and by that I just mean the long first paragraph, in Roman 2, where we say the subsequent order made by the BVI court entered on the 16th of July 2018, and which second order continued the appointment of Paul Pretlove in his sole capacity. I can take you to that order, but it simply removed Miss Barkhouse.
Yeah, I want you to take me to that.
Yes.
Please.
Or just give me a moment. I reread it this morning. Yes, if one turns in volume 1, page 44, and that's behind tab number 3. The reason why there are...
Oh, the 13th of July, is that right?
Yes,
No, the
it's
18th.
13th of July, into the 16th of July, reminding the court that the full order for liquidation in these proceedings was the middle part of January of the same year, there having been a provisional order made in December. The names the parties' names on page 44 reflect the fact that Stuart McKellar, a former colleague of Mr. Pretlove, was retiring, and all of the applicants are different constituent parts of the CALO organisation. Mr. Pretlove works for an insolvency firm called CALO. If one looks at the appendix at page 46, you'll see, just so that you see that it applies to FCI markets, page 46, almost exactly in the middle of the page, FCI Markets Inc.
Yes.
2017-0193. So you have that it applies to this. And then if you want to look back to page 44, you'll see that it says in relation to each, this is in numbered 1 of the actual order, in relation to each of the liquidation cases listed in the appendix to this order. And I've just taken you to FCI being listed there. Miss Angela Barkhouse shall be removed as joint liquidator. And it's a block transfer for the simple reason that costs are being saved by trying to deal with a number of different ongoing liquidations at the same time. I'm sure if a separate application was made, there would be criticism of Mr. Pretlove from at least one or other of the creditors or putative creditors. So that's when it happened. I don't know the exact date of Ms. Barkhouse's departure, but the point is there's a proper explanation for it, not only for it, but also why it is that she's not been replaced yet. Not replaced yet because at the moment there's a limited amount of activity at the recovery end. We certainly hope that that will change soon. So subject to that correction, or at least clarification in relation to the order, I wonder whether the court has any further questions on the draft order.
Yeah, I think I'm fine with this.
Obliged. We will, of course, supply to the court a
if you have
cleaned-up version.
So that we can change it to our standard.
Yes. Then unless I can assist in any other way, those are my submissions on behalf of the applicant in this application.
Well, I think you've done quite well, and I thank you for this. So you will have this order issued
I'm obliged.
today. Thank you very much, and I hope you have good experience with our court now.
Thank you. You've certainly been very welcoming and efficient.
Thank you.
Much obliged.
All right.